All right, I will call this meeting of the Judiciary, Finance, and Civil Law Committee to order. Today is February 28th, 2023. We do have a quorum. Before we get to the minutes, this is a reminder for everybody on the committee. In our rules for this committee, number 4 is that appropriate and respectful decorum is required, and that during the hearing, all presentations, discussions, and questions must go through and be recognized by the chair. We've struggled a little bit in the last week or so to follow that, and it is a privilege to do this work. And you lose the privilege to do the work of this committee if you cannot follow the rules. So if folks cannot be respectful to our testifiers, to our presenters, to each other, I will not be calling on you moving forward. There are consequences for actions, and you earn a privilege, and that is how I'm going to be conducting this committee going forward. So that goes for everybody. So I wanted to say that on the record, because on and off throughout this year, we've struggled a little bit as members, and I think it's important that we do follow that appropriate and respectful decorum, and that we extend that to everybody who is in this room with us, whether they are members or the chair or presenters. So with that, we'll move on to the minutes. Do I have a motion to approve the minutes for February 21st, 2023? Representative Moeller.
So moved, Madam Chair.
All right, Representative Moeller moves approval of the minutes for February 21st, 2023. All those in favor, please say aye.
Aye.
Opposed? The minutes are approved. All right, Representative Curran, we're back again. So members, this is the bill. We got the testimony in just under the wire last week. We had Mr. Watson from the city of Vadnais Heights here. Representative Curran, so we already took public testimony. There was nobody else here who wished to testify. We already had noticed it and had an opportunity for amendment, so we're just going to move it now that we actually have the fiscal note. We were hoping that we would have the fiscal note ahead of last week, and we didn't, but now we do. So Representative Curran, I will move, Representative Curran, would you like to move House File 1414 back before the committee?
Yes, so moved.
All right. And then would you like to refer the committee to the recommendation that we refer it to Ways and Means?
Yes, that is my motion.
All right. So now we'll move on. We have a couple minutes. I wanted to make sure we had time for member discussion since we were a little rushed at the end of our last hearing. So is there any discussion to House File 1414? Representative Johnson.
Chair Becker-Finn, Representative Curran. I don't have a problem with this bill. I think the funds should go back to the local jurisdiction instead of to the state with these issues. I'm just wondering why we don't have a set up so every county and every jurisdiction in the state is the same. It would make much easier for the state to do things. And so that's the only question I have. I did have an amendment, but I didn't get it in time to do that. So I'm just wondering why we don't treat every county the same, because even in greater Minnesota, our small counties and our small cities are struggling. They don't like to be the ones that are called speed traps, but I think if there is fines and stuff, we should treat every jurisdiction in the state the same.
Any comment, Representative Curran?
Sure. Thank you, Chair, and thank you, Representative Johnson. I agree with you there. I do think that we need to make sure that there's equity throughout the state. In this case, this is addressing a particular issue from my community, and that's why I'm bringing it forward today. So if there are other counties that could benefit from similar pieces of legislation, I would support those as well. If there's a way that we could in the future work on equity statewide, I'd be on board with that as well.
Representative Johnson, sounds like maybe you have a new bill idea. Any follow-up, Representative Johnson?
No follow-up, just if we went to the same as what Hennepin County has, which is a lot, would actually do better for Ramsey County.
All right. Any further discussion, House File 1414? All right. Any closing comments, Representative Curran?
Nope, we can keep it short and sweet. I appreciate the support.
All right. With that, members, Representative Curran renews the motion to refer House File 1414 to Ways and Means. All those in favor, please say aye.
Aye.
Aye. Opposed? All right. The motion prevails, and the bill is on its way to Ways and Means. We Do we have Representative Kozlowski? You know, all these,
Right.
oh, okay. I was looking for Representative Kozlowski. Sometimes our other members struggle with our 8:30 a.m. meetings, but I see Representative Kozlowski is here and ready to go. Welcome to the committee. I will move to re-refer House File 774 to the Capital Investment Committee. Representative Kozlowski, please tell us about your bill.
All right. Well, good morning, Chair Becker-Finn and members of the committee. I am here to talk about House File 774. Thank you for the opportunity for the hearing on this bill. It's really important for our Duluth community, but also for our state, in that it will provide funds to First Witness for the purchase and renovation of a larger building for a child advocacy center and a nationally recognized training center. I am personally wholeheartedly bringing this bill forward because since its inception nearly 30 years ago, First Witness has both grown in number of children served and services provided in response to cases of alleged child abuse. I've seen firsthand and experienced the need for these services, and First Witness Advocacy Center is really leading the way as a child-focused nonprofit agency offering hope and healing and justice for alleged victims of child abuse and for their families. As you may know, childhood trauma can last a lifetime and has been linked to adverse childhood experiences, or known as ACEs. In children, this leads to serious outcomes such as post-traumatic stress disorder, poverty, and other health problems that go unaddressed, and also has a lifelong effect on families, but also for our broader communities. So First Witness, who's here with me today, has a really bold vision that I believe that we can all get behind, right? We want a vision of a community, of a society that prevents and protects the littlest among us. And one of the things that they do really well is they partner with our schools, with tribal nations, and they offer robust and a comprehensive child abuse prevention program, serving the entire state with their nationally recognized training in child-focused forensic interviewing and family advocacy. Just this last year alone, they trained over 546 new advocates. So 10 years ago, First Witness served 70 children annually, and last year they served 220 children, providing child-friendly, legally defensible forensic interviews, intensive ongoing advocacy, mental health services, medical exams, and more. And they also facilitate a multidisciplinary team which works with law enforcement, child protection, and attorneys to accomplish the best outcome for our victim survivors of child abuse. So I'd like to turn it over to my testifier, and the first would be Tracy Klena, Executive Director of First Witness.
All right, Tracy Klena, welcome to the committee. Please introduce yourself and then go ahead with your testimony.
Great, thank you. Hello, Chair Becker-Finn and members of the Judiciary, Finance, and Civil Law Committee. My name is Tracy Klena, and I am the Executive Director of First Witness Child Advocacy Center. I'm really honored to be here today to talk to you. According to the CDC, 1 in 7 girls, 1 in 13 boys, and 1 in 4 non-binary youth in the U.S. will experience child sexual abuse before the age of 18. Every child has the fundamental right to be safe, to be treated with dignity, to be cared for, and to thrive in their community. Child abuse robs a child of this fundamental right. We as communities need to provide safety and justice to all children. First Witness is dedicated to the children and families in our communities. We offer a comprehensive and holistic child advocacy center to help those in need of our services. The moment a child walks in our door, we surround them with support so they are not alone during possibly the worst moments of their life. Through child-friendly interviews, advocacy, victims can heal from their trauma and find their way in the world again. As you can see in our summary, our impact continues to climb both in numbers and in services. First Witness sees our role in disrupting the cycle of violence and building safety both on the individual and the community level. Our team of professionally trained forensic interviewers protect child victims with safe, evidence-based techniques. Our family advocates build connections across systems to represent families' needs. Our prevention educators spend time in classrooms empowering children around safety, strategies, and freedom from self-blame. They train teachers, they train youth-serving professionals and parents, both on prevention and appropriate response. 30 years ago, our center was built to serve as a place for child-friendly forensic interviews performed by a multidisciplinary team of law enforcement, social services, and prosecuting attorneys. Since our beginnings, First Witness has expanded both our efforts in numbers served and services offered. This increase has led us to desperately need a new building. This new building would include child and teen-centered spaces, spaces for ongoing advocacy services, an additional forensic interview for those emergency cases, a multidisciplinary team space that allows for law enforcement and social services to truly respond to the needs of these difficult cases. And finally, a training center that would serve the entire state that will bring investigators and advocates from around the state and country to learn from our national model. The course of child abuse investigation is challenging to navigate. To address this, we offer a comprehensive and holistic child advocacy center that provides prevention, intervention, and systems change. Thank you for your consideration of this bill, and I'm happy to answer questions after our second testifier, Attorney John Holitz.
All right. John, if you want to come forward and introduce yourself for the record, and then go ahead with your testimony.
Thank you, Chair Becker-Finn, and thank you to the rest of you for listening to me this morning. My name is John Holitz. I'm an assistant St. Louis County attorney. I've been a prosecutor, and I've had the opportunity to focus maybe over the last 8 or so years on child abuse, child sexual abuse prosecution. And I can give you a lot of reasons why First Witness makes our job possible, but allows us to hold people accountable. I can give you a lot of reasons to support this, but I want to give you my 2 favorite reasons, because I know we're tight on time today. Number one, we need a space, we need a bigger space, and we need that space to be a special space. It's got to be authority reducing. Can you imagine if you were, instead of me sitting here, a kid sitting here testifying? Now imagine in a courtroom that's built on authority for law, authority for judges. That's an intimidating space for a kid to walk into. It's particularly intimidating when a kid walks in and the person on trial might be a loved one, somebody they trusted, somebody they cared about, somebody who took care of them. More than testifying, they probably want to run over and give that person a hug, despite the terrible things that maybe they've done to them. So that's, we're in a system built on authority. We're in a system anchored on authority, and that works really well for adults. It does not work well for kids. Kids have difficulty testifying. We, First Witness Child Advocacy Centers, are built on a model of authority reduction because we know that when authority is reduced in an interview process, it creates more truthful, more accurate interviews. And so we need to have a space that reduces authority. Unlike a space like this or a courtroom that creates authority, we want one where we meet kids on the level that they're at. We want to have an interviewer who comes in and can talk to them and reduces the stress and allows them to answer questions. So the place that we have right now does that, but it's too small. And so we've purchased new buildings that are going to do just that, and they're particularly special, and they will work like that. They'll look like, on one side, they look like, because they used to be apartments, so it looks friendly, it's child-friendly. The kids walk in, they know that they're coming to a safe place that reduces authority. So that's why these buildings are so special. They also give us separate accesses so that law enforcement officers, people with guns and badges, lawyers like me, when they're walking in to do these interviews, we're not walking by these kids, we're not creating authority, we're reducing authority. The other is training, and I know that that's been mentioned briefly, but one thing that we do that we are proud of, one of the many things we're proud of, but one of the things we're particularly proud of is the training that we provide, not just to Duluth, not just to Lake, St. Louis, Carleton, Cook counties, but all around Minnesota and beyond. We're proud of the ability to have something that we think is really special, that we're really proud of, and then be able to share it to other communities who don't have that, to train their staff to go back to conduct these types of interviews. That's something that I'm really, also really proud of, and it's something we need more space to do, because right now we're begging and borrowing and stealing space to be able to do that, and that's not good. So I'd ask you to support this. We need the funding to be able to do this. Thank you.
All right, thank you so much for your testimony, and thank you to both of you for the work that you do. I know those child abuse and child sexual abuse cases, as the prosecutor and the person who has to go through all that evidence, some of the hardest work that attorneys can do, so thank you for your service. Any other members of the public wishing to testify on this bill? All right, not seeing any, we'll move on to member discussion. Representative Finke.
Thank you, Chair Becker-Finn, and thank you, Representative Kozlowski, for the bill. And, you know, your second testifier mentioned a little bit about this, but I was just going to ask if you could tell us a little bit about how this money in these buildings would benefit not just the people behind the work, but the community that's being served. And maybe you have some additional thoughts on that.
Representative Kozlowski.
Thank you, Chair, and to Representative Finke for that question. And as my testifier illustrated, behind the scenes for the multidisciplinary team, but also for families. The building that is currently in is, I believe, about 2,000 square feet, and quite literally the team and community and the folks who are being served are busting out of the seams of that space. And so I'll ask Tracy to talk a little bit more about, the broad impact, but the ability to also not only be able to bring the team in, the service, the medical providers, the law enforcement, the legal teams, and give them the space to be able to do what they need to do together, instead of having to shop that out to the community and to find spaces, but also the ability to be able to serve multiple families and multiple children at the same time.
Executive Director Klana.
Yeah, thank you, Chair Becker-Finn, and thank you for the question, because that's exactly what we're looking to do. The original vision of the building was really about that single child that was telling their story to the multidisciplinary team. Over the last 30 years, we have really broached into the community, worked closely with those families that are affected by child abuse, but more importantly, worked more closely with our partners in the community, from schools to youth serving agencies to hospitals to law enforcement, all of them having a space to not only navigate the investigation of these cases, but also to respond in a trauma-informed way, and that's exactly what this space will do. Thank you.
Representative Johnson.
Chair Becker-Finn, member, just got one question and a brief comment about this. First of all, the question to testifier Kalana. What is the local match that's going into this program for this grant? Generally, we require a local match as well. I'm just one thing I'm also wondering why it's in this committee. Normally, these are through OJP, which goes through Public Safety and not the Judiciary Committee, but I'm glad it's here because some of these members need to understand why we got to this program. But first of all, what is the amount of local match?
And actually, but before you answer that, I'll just let you know, as the chair of the committee, I was very interested in what they're doing in this program, and I wanted to lift up how important this is. You know, we do have jurisdiction over court stuff and child protection, and I just thought this was a really important program and wanted to lift it up. So as the chair, I asked to have it come to my committee because I thought it was really important. They've been doing this work for decades and are successful. So that's why it's here and not straight to capital investment. And then I'll go to Executive Director Klana to the local match question.
Great. Thank you, Chair Becker-Finn and members of the committee. Our local match will be $2 million. Our total project is $3.5 million. We are in the middle of a capital campaign raising those local funds. We have raised about $1.1 million of that $2 million local match, and we are well on our way to reaching that goal.
Representative Johnson.
Chair Becker-Finn, Executive Director Kalana. Thank you. I think it's important for the local communities to be involved in these. I actually have a child advocacy center in my district. I was asked to be on the board of directors on that one, but because I'm a legislator, I said no, because I'm working on funding and stuff like that. But I want to get a little bit of the history why for the members that probably don't know how we got here to have these child advocacy centers. 38 years ago, situation arose in Scott County, and it was a fiasco. Made a mess of the entire system and put a lot of these cases at risk where the perpetrators could not be tried. But it also, in the Scott County, it indicted and charged a large number of people. I think it was around 50 that should never have been charged because of false accusations. And from that experience, we got into these child advocacy centers, which is a one-stop shop for all the needs. It's for a child, it's just one interview. Everybody's there. All the services are there. The prosecutors are there. The law enforcement investigators are there. Mental health professionals are there. And a very specifically trained interviewer is interviewing these children. It's a great program. I support it 100%. But generally, the grants have been into not specifically named. They've been to a normal fund, and it's a competitive grant for these because we still need about 5 of these across the state to get things covered the way we need. And this is taking funds that could help areas where people have to drive 200 miles to get to one, and taking those funds but it's a good program, so it's an area that we need to work on, get more funding, get more advocacy centers set up, because they're so important, not only to make sure that we get the proper interview of these children, but also to protect those that are actually innocent, because the interviews are so detailed. It protects the innocents, but makes sure they get the proper evidence to charge the perpetrators that are actually doing this. So thank you for bringing this. It's a great program, but I'm just concerned that we're bypassing other areas of the state that need these as well.
I don't know if you've ever made the drive from Grand Portage to Duluth, but that's not a short trip either. So any comment, Representative Kozlowski? Otherwise, we've got a couple people on the list.
Right, and I appreciate you sharing the history and the background and illustrating that for us. I think the importance of having these centers that not only serve our community but broadly statewide, as illuminated in the counties. I was going to ask our testifier if you go out to the children and families too, which I thought there was a component of that, but I think having the investment of both the state and our local communities is really important as well. Thank you.
All right, Executive Director Klana, and then we got to move on because I've got a lot of bills on the list today. But Executive Director Klana.
Yeah, I just wanted to say thank you, Chair Becker-Finn, and thank you for your comments and questions. I will say that is one of the reasons that we do need a larger building, because we have expanded our services. Originally, they were just in St. Louis County. Currently, our core services are in Carleton County, Lake County, Cook County, which, yes, is a long drive. However, those local law enforcement agencies and social service agencies are supporting the family in getting to our center.
Thank you. Representative Moeller.
Thank you, Madam Chair. And as I read this is for the building, and there is another bill that we are hearing in public safety for victim funding in general that the different advocacy groups are bringing together, but that's separate from the building that's in here. So I just wanted to make that very clear. Both things are important. I don't think it's an either-or situation. So, and I'll just say that as a prosecutor, I have watched way too many of these videos over my years, and I can still very vividly remember some of the things. So what the work you do is so incredibly important. also so there's a lot of criticism about prosecutors not prosecuting cases, and I think people need to understand that if a child victim is unable to testify, that case actually cannot go forward because of the confrontation clause. And so the work that this group and other advocacy centers do really ensures that the child's able to tell their story in that trauma-informed way, and that if there's an ability to prosecute the case, you will. But if the kid just shuts down and can't do it, you really, really are unable to prosecute those cases and hold offenders accountable. Thank you.
Thank you, Chair Moeller. Representative Curran.
Thank you, Chair. And thank you, Representative Kozlowski, for this bill. I think this is an amazing program. And just kind of a quick question for you. During the testimony, I had kind of heard, the environment that this provides for children who are survivors of sexual abuse. This environment allows for a more truthful and open interview. So looking at this sort of from a public safety lens, question for you, Representative, is do you see programs like this helping to prevent future abuse and sort of based along the lines of Representative Moeller's comments?
Representative Kozlowski.
Yeah, thank you, Chair, and Representative Curran. Absolutely, and I think that investing in a program like this not only seeks to end violence when it happens, but their First Witness is really leading the way in being out with their schools, out with youth, with families, in community-based settings to really help children and families understand the signs, to be able to tell their stories and understand who they can talk to and so much more. And I'd invite you if you want to chime in about more pieces, but that is a really big component as being able to prevent. And this would actually, investing in this center and in this space and this team would allow them to expand that prevention work as well.
Executive Director, any response?
Yeah, thank you, Chair Becker-Finn. I also want to add, thank you for that question. We know that child abuse can be multi-generational, and if we are giving children and their caregivers the opportunity to heal from that child abuse through therapy, through advocacy, through community supports, that violence in that family may stop there and not continue to have that multi-generational impact.
All right, thank you. Representative Kozlowski, any closing comments?
Yeah, I just want to close by saying thank you again for this opportunity. As we've heard, not only is this going to provide a better experience for children and families in Duluth, it's going to be able to also continue to help us prevent and intervene and disrupt those cycles of violence, all grounded in dignity and compassion. And so for years to come, this is a really important investment and ask for your support.
All right, thank you. With that, I will renew my motion that House File 774 be re-referred to the Capital Investment Committee. All those in favor, please say aye.
Aye.
Opposed? Motion prevails. Thank you very much to our testifiers as well.
Thank you very much.
Representative Elkins. I can't see through all the tall chairs to know who's in the room. All right. Representative, moving right along, Representative Elkins, I will move to re-refer House File 1326 to the Transportation, Finance, and Policy Committee. Let's see, and Representative Elkins, you do have an A1 amendment. Do you want to do that first?
Yes, Madam Chair.
All right, I will then move the A1 amendment. Representative Elkins, if you could tell us quickly what the A1 does.
The bill as a whole is designed to close a loophole in the Data Practices Act related to the collection of selected transit data, and my testifier will explain that in more detail, but as written originally, it only applied to Metro Transit, and this is a provision that should apply to all transit agencies statewide.
All right, any discussion to the A1 amendment? All right, seeing none, all those in favor, please say aye.
Aye.
Opposed? The motion prevails. The amendment is adopted. Representative Elkins, please tell us about your bill as amended.
Yep. So, Madam Chair, this is one part of about a 7-part Metropolitan Council housekeeping bill. and different pieces of it have to go to about 4 or 5 different committees. So we're going to have all of these pieces eventually end up in state and local government, where we'll put them back together into an omnibus housekeeping bill probably next year. And I have with me Dennis, who will be explaining the particulars of the bill.
All right, please introduce yourself for the committee and go ahead with your testimony.
Madam Chair, Dennis Dorshak from Metro Transit Revenue Operations. The purpose of this legislation is to increase the consistency in protecting the private data of our customers who are using our fare products. We request to include data that's not currently protected, such as by telephone, third-party software, transit assistance program members. We want to include all personally identifiable information, date and time the fare product was used, the mode of travel, the type of fare product. And we want to include other agencies that are not, other modes of transportation that are not included, such as Metro Mobility, smart cards, Transit Link, microtransit, the paper tap applications or any kind of tap applications. And this is right now it's difficult to manage because of the different policies fall under different categories. So we'd like to get some consistency within the legislation.
All right. Are there any other members of the public wishing to testify on this bill? All right, please introduce yourself for the record and proceed with your testimony.
Madam Chair, members of the committee, my name is Rich Neumeister. This is just an additional information that is becoming private, which I believe it should, but also it's a growing program of where transit go cards are being used and special programs for discount of fares. And one of the things that with the discount go cards and all of that, location data is becoming more accumulated by Metro Transit. And so one of the concerns I have is that if location data and your smartphone that you have, there needs to be a tracking warrant or a search warrant based on probable cause. But here we have a government entity collecting more and more location data, particularly on a lower income, and they should have the same kind of protections as I think other folks have with search warrants. Now, I have spoken with the staff of the Met Council, and they've said, well, it's other authorized by law, whatever is authorized by law. And that can mean just maybe data sharing. That can mean maybe by a court order. I think it's important to just say, hey, let's have one standard. Let's have a search warrant. So, Madam Chair, members of the committee, sometimes when legislation like this goes through, it brings just more issues that sometimes if it's not addressed now, it should be eventually, but this is an opportunity to share a point of view. Thank you very much, Madam Chair, members of the committee.
All right, thank you for your testimony. Any further members of the public wishing to testify on this bill? All right, not seeing any. Move on to member discussion. Representative Scott.
Thank you, Madam Chair, and thank you, Representative Elkins. I had a discussion with him on the House floor yesterday. My concern is that there's no Tennyson warning given to the applicant so that they would know that on lines 3.1 of the bill, it says the council may disclose transit assistance program data to public or private agencies or organizations for the purpose of administering and coordinating human services, et cetera. And in addition to what Mr. Neumeister just spoke of, it's akin to having an app on your phone that tracks your whereabouts. So that is a concern too, but I do believe that maybe, and maybe the testifier could answer this question, is it possible to put a Tennyson warning on the application so that these folks that are entering into this program would know that their data could be shared for these purposes? And really, Madam Chair, I'd like to see the audit trails and all that, so when that information is shared, these applicants can go back and get the information of who their data has been shared with.
Senior Manager Dorshak.
Madam Chair, Representative, yes, of course, the council does have a Tennyson warning that we do, by practice, use for our fare products, and this will be included in the TAP program, correct?
Representative Scott?
Thank you, Madam Chair. I'd be glad to work with Representative Elkins and talk through the other aspects that I think the audit trails and so forth on this program. So thank you.
Yeah, thank you. And to clarify, so this information is already being collected and we're trying to reel this in to protect it. So anything we do in this bill is better than what's currently happening? Is that, okay, I see nodding heads. Okay. Any further discussion to this bill? All right, Representative Elkins, closing comments.
Thank you, Madam Chair. And I would say that I have been doing a lot of work on locational data privacy more generally, and have already on my list of interim projects is to bring something to the Data Practices Commission this summer that would propose probably a more sweeping update of the whole Data Practices Act as it relates to locational data privacy.
Well, you better talk to Representative Scott before you get something jacketed, or we don't want to spend all that time in committee. So
it's an interim project.
Yeah, sounds good. All right, with that, I will renew my motion that House File 1326 as amended be referred to the Transportation, Finance, and Policy Committee. All those in favor, please say aye. Aye. Opposed? The motion prevails. Yep, thank you, Representative Elkins. I did see Representative Hanson J. in the room earlier. All right. Representative Hanson, welcome to the committee. I will move your bill, House File 1521, be referred to the Children and Families Finance and Policy Committee. Let's see, this is so just for reference, this is a Department of Human Services policy bill. And Representative Hanson, I understand you have an A1 amendment. Would you like to move that amendment right away?
Yes, please, Chair.
All right, I will move the A1 amendment. Representative Hanson, please tell us about the A1.
Thank you. The A1 amendment just gets my bill into the shape that we would like it to be in.
All right, all those in favor of the A1? Please say aye. Opposed? Motion prevails. All right, Representative Hanson, to your bill as amended.
Thank you, Chair, and thank you, members of the committee. This will be very quick, hopefully. HF 1521 is an agency bill that addresses technical and housekeeping changes needed for the statutes that are governing child welfare, child support, and the Federal Supplemental Nutrition Assistance Program, or SNAP. Provisions related to child welfare aligns effective dates for the Northstar Care for Children payment rate assessments with existing practice. It ensures that statutes governing relative searches include all relatives as defined in existing law, and it corrects an incorrect statutory cross-reference. Changes related to child support provide clarity on when a court can deviate from child support guidelines when a recipient's income increases. And finally, the bill repeals a statute related to the SNAP program that is not in compliance with the federal laws governing SNAP. Only the child welfare and child support provisions are within this committee's jurisdictions, and those can be found in sections 1 to 4 and part of section 5. So this, I have with me Jennifer Sommerfeld from DHS to just give you a quick overview of each section as well. Thank you, Chair.
All right. Director Sommerfeld, if you could introduce yourself for the record and then proceed with your testimony.
Thank you, Madam Chair. Members, I'm Jennifer Sommerfeld. I'm with Department of Human Services. And Representative Hanson really described the bill well, so my section-by-section review will be very brief. As Section 1 of the bill is related to the Northstar provisions that you spoke about, making sure that the timelines for effective dates for the new rates or the original rate are aligned with current practice, so that it's not confusing for counties and families. Section 2 is related to relative searches. There was an error in drafting when we made some changes a year or so ago, and the way this reads right now, it looks as if we're excluding actual relatives of a child and instead only allowing relatives, adult relatives of a child's sibling. So we're making a technical change here to make sure that that can't be interpreted in the incorrect way. Section 3 simply deletes an obsolete cross-reference that doesn't exist any longer to make sure the statute is correct. Section 4 makes a technical housekeeping change to a child support statute. Right now, it would appear that if a child support recipient's income went up, that you could not reduce child support for the person who's paying support, which is not what was intended when that language was passed I think in 2021. And then Section 5 is a repealer of a child support section that no longer is needed. It's related to charging interest on child support, which was eliminated a couple of years ago. We no longer charge interest. So that's the bill.
All right. Let's see, it looks like we have one other testifier. Do you want to move on to the other testifier? Maybe we don't.
Chair, I think we had somebody else that was on deck in case
Got it.
Jennifer was bouncing between my other committee and this one. So-
Very smart. Okay, so we don't have the other person on the list. Are there any other members of the public wishing to testify on this bill? All right, not seeing anyone. Any discussion? Representative Scott.
Thank you, Madam Chair, and thank you for bringing this bill, and thank you for reaching out, Ms. Sommerfeld, on this issue. And just so members, because we haven't done a lot of family law on this committee, in Minnesota, we work on this income shares model to establish the amount of child support. And many times, most normally, I guess, and Ms. Sommerfeld can clarify this because she knows this like backwards and forwards in her sleep, but if they base the child support on the combined incomes of the parents. And when one goes up, then the child support is usually adjusted. And so I'm happy in this situation that when the recipient's income goes up, which is always awesome, that it doesn't mean now that the combined income is more, that the child support amount has to go up for the person that's doing the paying. So I just wanted to make that a little bit of a clarification for the committee members that that's how that works in Minnesota. And Ms. Sommerfeld could correct me if I didn't get it right, but thank you, Madam Chair.
Yeah, we're hitting all the things that we work on in a bipartisan way today with the data and the child support, fixing child support. Any comment to that, Director Sommerfeld?
My only comment is that one thing I will note is that it's very unlikely, if not impossible, that will actually occur, that there would be an increase in the way the guidelines are put together. There only would be at some very low incomes. So,
got it. Any further discussion to the bill? Right, not seeing any. Representative Hanson, any closing comments?
Thank you, Chair, and thank you, members of the committee. I appreciate the quick discussion on this and getting this moving so we can continue to do what's best for children and families in Minnesota and make sure every kid has a great start here in Minnesota. Thank you.
All right, with that, I will renew my motion that House File 1521 as amended be referred to the Children and Families Finance and Policy Committee. All those in favor, please say aye. Aye. Opposed? All right, the motion prevails. Thank you, Representative Hanson. I did see Representative Tabke's head above the other chairs, so he's a little bit taller. Representative Tabke, welcome to the committee. I will move to re-refer House File 1347 to the Transportation Finance and Policy Committee. Members, this is another department policy bill, so very exciting morning here in our committee. Representative Tabke, please tell us about your bill.
Thank you, Chair Becker-Finn. I'm a little taller and a little shinier than most everybody else, so
I wasn't going to say that
I appreciate
part.
you pointing me out back there, so thank you. This is a MnDOT bill, and what basically is Marketable Title Act, and so what this does basically is if there is easement on lands that is not, if it doesn't look like it's being used, if it doesn't appear like it's being used, and somebody else wants to take control of that easement, this makes it easier and cleaner for MnDOT to be able to maintain control of that easement, and we have staff from MnDOT here to explain further.
All right, please introduce yourself for the record and proceed with your testimony.
Madam Chair, committee members, my name is Joe Pignato, and I am the Director of Land Management for MnDOT. Today I'm here to talk about the Marketable Title Act. Today, with the Marketable Title Act, easement owners are subject to a 40-year abandonment presumption. MnDOT and other state agencies and departments are not specifically identified in the Marketable Title Act to assert what's called a possession exception. Since this issue of whether MnDOT can assert the possession exception has previously been raised by some property owners, it is very likely that in the future further claims will come up. So MnDOT, we feel that if, for this reason, MnDOT believes the modification should be added to the Marketable Title Act to ensure the integrity of the trunk highway system. This proposed modification adds MnDOT and other state agencies to the list of entities that can raise the possession exception in the Marketable Title Act. So pretty straightforward. Thank you very much for your time, and I'm here to answer any questions you might have.
All right. Anyone else wishing to testify on this bill? I'm shocked. Members, any discussion to House File 1347? Representative Niska.
Thank you, Madam Chair, and thank you. I was hoping that the testifier from MnDOT could help explain a little bit more about what it means that MnDOT has, what does it mean for MnDOT to have possession of an easement in order to be able to assert this? You know, and we're talking about something that's potentially more than 40 years old, and so what does that look like in the real world for someone trying to clear title on a piece of property, and that MnDOT might have an easement that they're asserting the possession exception on?
As fun as it would be to have Representative Tabke try to answer that question, Director Pignato.
Madam Chair, Representative, with our easements, a lot of the time, folks will just see some grass sitting out there, and we're not, quote unquote, within the possession of the easement at the time. But the reason that we have a lot of the, leave it as grass, is that for snow removal, drift reductions, for drainage issues, for, you know, a lot of things that aren't driving on the road, putting pavement down, putting a turn lane in. So that's where, in the actual Marketable Title Act, under the possession exception, it calls out like a person, a corporation, another entity. It doesn't specifically say state agencies, and we've been challenged that we couldn't use the possession exception under subdivision 6. So this is just more of a clarification for us to say, you know, state agencies also can use the possession exception. It doesn't exempt us from showing possession, it just allows us to use that possession exception.
Representative Niska, any follow-up?
No, I don't have anything further. Thank you.
All right. Any further discussion to the bill? Representative Tabke, closing comments.
I have none, Chair. Thank you.
All right. I will renew my motion to re-refer House File 1347 to Transportation, Finance, and Policy. All those in favor, please say aye.
Aye.
Opposed? All right. Thank you.
Thank you.
All right. Do we have representation? All right. Representative Carroll.
While we're waiting for the next one, I just thought I'd give you the opportunity to explain the statute against perpetuities.
All the lawyers laughed.
If you even know what it
The
was.
rule against perpetuities, everybody's favorite. Representative Herr, thanks for hustling down here. See? Sorry, guys, lawyer jokes. We could talk about the bundle of sticks next.
There you go.
All right, Representative Herr, thank you very much. We're clipping along with some very scintillating policy bills this morning, but now we're on to your bill. So I will move to recommend House File 1625 be re-referred to the Labor and Industry Finance and Policy Committee. I do see you have an A1 author's amendment, so I will also move the A1 amendment. Representative Herr, if you can just clarify what that A1 amendment does.
The A1 amendment was just fixing an oversight of when we had the bill redrafted from a 2020 date to 2024 date. So it's
Yeah, changing the effective date to somewhere in the past is interesting. Okay, so all those in favor of the A1 amendment, please say aye.
Aye.
Opposed? The motion prevails. The amendment is adopted. Representative Herr, please tell us about your bill as amended.
Thank you, Chair Becker-Finn, and I hope that when I walked in, you weren't laughing at me, you were laughing with me, or you're laughing at something else that had nothing to do with
For the record, we were laughing at Representative Carroll's very funny lawyer joke about the rule against perpetuity, so it had nothing to do with this very good bill that's in front of us.
Thank you so much.
Representative Herr.
Thank you, Chair Becker-Finn and members. This morning, I'm presenting House File 1625, the Preventing Pay Discrimination Act. I think this is the first time I've been in front of this committee to present a bill and not being part of the committee. I was on it for 4 years, but it looks like the committee is in good hands with all of these great members. This bill is actually not new to this committee. This bill actually passed out of Judiciary and out of Labor last biennium, and it was heard as a standalone bill in the House floor and passed with bipartisan support on a vote of 80 to 51. So this bill is very straightforward. It simply prevents an employer from asking what a job applicant's pay history is when they're negotiating their salary. However, this bill does allow a job applicant to voluntarily disclose their pay history, and if they do so, then the employer is allowed to use this information as necessary. Above all else, House File 1625 takes us one step closer to closing the pay gap in Minnesota. The pay gap in Minnesota is very real. I'm not sure the last time the statistics were presented in front of this committee, but women get paid 80 cents on the dollar for what a man makes. This drops even lower for women of color. Asian women make 71 cents on the dollar, and when you disaggregate that, Southeast Asian women actually make closer to 50 cents on the dollar. Black women make 59 cents on the dollar, and it's even lower for our Somali women. And indigenous women make 56 cents on the dollar, and Latinas make 53 cents on the dollar. So with House File 1625, we work to close the pay gap by saying that a job applicant can no longer be forced to disclose their pay history during their salary negotiation. Some of you may be wondering why and how this contributes to the pay gap, but to help close the pay gap, this helps close the pay gap because the pay history question can give an employer a built-in excuse to pay a job application less because they are basing that decision off of someone's past history. The reason why they can do this is because the 1963 Federal Equal Pay Act actually facilitates the pay inequity. Employers sued under the Federal Equal Pay Act for paying women less will commonly defend their unequal pay practices by contending that they set salaries by relying on each job applicant's pay history. The United States Courts of Appeals from the 8th Circuit, which covers Minnesota, has accepted this argument, holding that it does not violate the Equal Pay Act for an employer to pay women less if the employer determined pay scales by relying on pay history. By ending the pay history question, a job applicant's future wage will no longer be anchored down by their past, and we can break the cycle of discrimination that can follow women and BIPOC sometimes throughout their entire careers. It's also important to note that 18 states, including Alabama and North Carolina, have already passed their own pay history question bans. In 2020, a study by research at Boston University School of Law found that enactment of state pay history bans actually closed the pay gap 5 to 6% on average, and for female job changers, this increased their pay by 8%, and for African Americans, that was by 13%. In other words, adopting the pay history bans reduce both gender and racial wage gaps. It's time for Minnesota to step in to close the gap, to close our gap. So with me today, Chair Becker-Finn, I do have Commissioner Lucero from the Department of Human Rights to testify in favor of the bill and to answer any questions that you all may have. So if she is here, I'd love to bring her up.
Commissioner Lucero. Welcome back to the committee. Please introduce yourself and proceed with your testimony.
All right. Good morning, Chair Becker-Finn, members of the committee. My name is Rebecca Lucero, and I'm the Commissioner for Minnesota Department of Human Rights. It's good to be back here with you this morning. First, I want to thank Representative Herr for carrying this agency policy bill, and to the committee for giving the bill a hearing. So House File 1625, otherwise known as the Preventing Pay Discrimination Act, will help close Minnesota's gender and racial pay gap. As Representative Herr explained, it prevents pay discrimination from taking place when a Minnesotan applies for a job or negotiates their pay. It simply says, don't ask an applicant to disclose their pay history. Now, there are 3 reasons why it's important to be intentional about eliminating the pay history question. So first, women are consistently paid less than men with similar experience, qualifications, and seniority in the same position. And that pay gap increases for women of color and indigenous women. And Representative Herr provided some of those really concerning statistics around that. Now, there are many reasons why this exists. And one of the things we should do is start by looking at the structural systems that contribute to this outcome. So Professor Hasday, a law professor for the University of Minnesota, has joined us several times over the year, not today, but several times over the years, to testify about this bill. And she always starts her testimony by sharing that before 1963, it was perfectly legal for employers to pay women less. And it was, in fact, the norm to see help wanted ads that would list one salary for men and a lower salary for women for doing the exact same work. So the Preventing Pay Discrimination Act helps break this systemic discriminatory cycle that has not yet ended. Secondly, the gender wage gap persists even after the passing of the Equal Pay Act. And in fact, in Minnesota, we have not narrowed this over the past 5 years. So why is that? If an employer is supposed to pay men and women the same for the same work, why isn't that happening? It isn't 1963 anymore. And yet the same results of paying men and women differently persist, especially for women of color. So one important reason for this persistent wage gap is that employers frequently ask job applicants about their pay history before deciding what salary to offer. In fact, employers oftentimes ask it as part of the initial application, long before an interview has occurred, meaning that they're actually even taking that information into consideration about who should even receive an interview. So to be intentional about closing the gap, we look at what policies or practices, what formal policies and what informal policies are perpetuating this inequality in pay, resulting in this discriminatory outcome. The use of the pay history question is one of these practices that is neutral on its face, but in practice often causes inequality in pay. Again, if Professor Hasday was here, she would remind us, and echoing comments by Representative Herr, that in Minnesota, it does not violate the Equal Pay Act for an employer to pay women less if the employer determined pay scales by relying on pay history. This means that without this bill, an employer can pay a woman less than a man for doing the same work, so long as the employer can point to the woman's pay history as a basis for that discrimination, this discriminatory outcome. Again, this means that someone can be locked into this cycle of unequal pay that will impact them throughout the rest of their lives. The Preventing Pay Discrimination Act, again, aims to break this cycle. So the third reason is it works. In states that have eliminated the pay history question, they saw an 8% increase for pay for all women and a 13% increase for pay in black workers. This is good for Minnesota. I've had the pleasure of testifying about this bill multiple times, as you know, and when I do, I usually get a couple of key questions that I'd like to address. So the first question I get is, hey, how does this bill relate to current discrimination law? And I want to make sure that I'm providing that information, that this bill is fully aligned with the rest of the Minnesota Human Rights Act, as well as federal law, which often requires a burden-shifting analysis when deciding whether or not discrimination occurred. So right now, when someone contacts our office, they have to show that they have what's called a prima facie case. They have to meet the prima facie elements, alleging facts adequate to support their legal claim. At this point, the burden shifts to the employer to articulate a legitimate, non-discriminatory reason for what occurred. And if an employer is able to show that legitimate, non-discriminatory reason for what occurred, the burden then shifts back. So there's this back and forth burden shifting. So for this bill, this means that if an employer uses a job applicant's past pay to set their wages, then it will be the employer's responsibility to explain why did they do that, which is in alignment with discrimination law today. The second question I get often is this difficult to comply with? Nope. This is a simple bill to comply with, which is demonstrated by the fact that many employers have already started making this change because they understand the importance of this. This is easy for small employers and big employers in the exact same way that employers cannot consider, for example, if someone is or is not pregnant. They also would not be able to consider previous pay. I myself have hired many employees myself throughout my career, and it's easy to comply. I simply do not use salary history when making an offer. So when someone applies for a job, I consider their qualifications, I consider their experience, I consider whether or not they have any relevant education experience. I certainly consider the market, but I don't ask if they're pregnant. I don't ask about their age, and I don't ask about their salary history. In closing, I want to highlight all the support that exists for the bill. That includes the Minnesota Council of Nonprofits, Min Legal Aid, and Girl Scouts of River Valley, all of whom speak about how important it is to close the pay gap. When Minnesota passes this bill, we will join a groundswell of over 20 states that have already ended the pay history question and will bring Minnesota one step closer to closing the pay gap. Thank you very much for the time, and I stand for any questions.
All right. Are there any other members of the public wishing to testify on this bill? All right, not seeing any, we'll move on to member discussion. Representative Finke.
Thank you, Chair Becker-Finn. I know that we're pressed for time, so Representative Herr, and Commissioner Lucero, I'll just put a quick plug in for expanding our data collection so that we're making sure we are collecting data on all members of our community, and point out that trans women make about 60 cents on the dollar to men, and this is an extremely important bill for our community. Hiring trans people is not an act of charity, and we deserve to be paid just like everyone else.
Thank you. Representative Curran.
Thank you, Chair, and thank you, Representative Herr, for bringing this forward. I know this has been heard in the body before. It's my first time, but when I saw this, I was really excited. I know we have attorneys that giggle and geek out over some of the stuff in this committee, but I also am a human resources nerd. So I worked in human resources for several years. I interviewed hundreds of applicants, and what I noticed time and time again is that past pay has absolutely nothing to do with skill level, competency, anything like that. It's, in my mind, asking for pay history is really just fishing for cheap labor and not looking at the best possible work and actually just honestly paying for the work that needs to be done. And I think that's where we need to head. And so I appreciate you bringing this forward from that perspective.
Right, thank you. And I'll say in my experience interviewing people too, I did want to point out subdivision C, that if the applicant were to disclose because they think maybe disclosing that they make more money at their current job as a negotiation, that there is a ability, if the applicant thinks that it's going to help them in their negotiation, they do have the ability to do that under this, this language of this bill. Next on the list, I've got Representative Johnson.
Chair Becker-Finn, Representative Herr, I'm just wondering how this is going to affect our state's largest employer. The state of Minnesota and our local governments and school districts and colleges combined is the largest employer in the state of Minnesota, well over 400,000 employees. And by statute, all their salaries are public. So their information is out there, but they can't, but on this bill, it can't be disclosed. How is that going to mesh with this program?
Well, I can actually, Representative Johnson, I'm going to point you to line 1.17, and then I'm going to go to Commissioner Lucero. Go ahead.
Great. Chair Becker-Finn, thank you very much, Representative Johnson, for the question. So in great news, the state already does not consider past pay as part of its analysis. So right now, when I work to hire people, there's a whole analysis that I do based on their level of education, what else is going on in the market, et cetera, and I fill out that form, and that's how I make my basis. It is really well defined that way. Now, of course, both if you are a current employee, if you're a current employer, private or public, or the information might be out there, that is outlined in here. And so there are many things that you might know. You might know, for instance, that somebody is pregnant. You cannot use that in determining their salary. You might know their age. You cannot use their age in saying, actually, I don't want to hire somebody of that age. And this is saying you might know what their salary is. You can't use that in determining what their current or future salary will be.
Representative Johnson.
Chair Becker-Finn, I just want to make sure that people understood that even though a salary is public information, when they're looking at hiring somebody, they can't use it. But that goes in, that can be two ways. I'm going to take a very good friend of mine, was offered a different job. It was 40 miles one way less driving, but a 65% decrease in pay. It would have been a lot larger decrease in pay, but they knew that person's salary, so they bumped it up dramatically to get that person to come and work for them, which is now only a 2-mile drive from where they live. So sometimes it can work the other way. Knowing the salary that they're at can actually, when they're looking at changing jobs for different reasons, can actually increase their pay. So it works both ways. So it's just something to consider. I understand this, and I understand why we want to do this, but we got to also remember it can work both ways.
All right, we've got a couple members on the list, so I'm going to keep going. Representative Niska.
Thank you, Madam Chair, and thank you, Representative Herr. My question really is focused on the rebuttable presumption language and starting in line 1.13, and I'm curious as to whether the other states in which this is done also use a rebuttable presumption like this, and whether that's necessary to reach the goals of the statute.
Commissioner or Representative Herr?
I would give my response of maybe around law schools, but I think Commissioner Lucero might be a better person to answer the question.
Commissioner.
Chair Becker-Finn, Representative Nesbitt, thank you for that. So there are over 20 states that have moved on this kind of ban, and there's different ways that states have enforced this policy. Some states took a civil penalty route, some states take more of a discriminatory analysis route. Here, we have taken a discriminatory analysis route, and that means that if an employer is found to be in violation, it will be their responsibility to explain why they used the pay history question to determine a job applicant's wage. So it varies across the country.
All right, follow-up, Representative Niska.
Yes, thank you, Madam Chair, and Representative Lucero. Of the states that do use this,
I'm happy with my job.
sorry, Commissioner Lucero. Commissioner Lucero, following up on that, you said that some states use the discriminatory statute or approach. What are there other states that define it as a rebuttable presumption using this kind of language? That was my question.
Commissioner.
Sure, Chair, Representative Nesbitt. So rebuttable presumption is a standard concept in anti-discrimination law, and I hope I provided some context to that in my testimony. It's very familiar, completely standard in employment and labor law, and it provides clarity on what the next steps will be and if an employer is found to be in violation of the law. So if an employer used a job applicant's past pay to set their wages, it's their responsibility to explain why they did that. The rebuttable presumption language sets that clear standard for employers and job applicants and makes it easy for instance, small employers to know exactly what is being asked of them and what's being prevented of them from being asked.
Representative Niska.
Thank you, Madam Chair, and Commissioner. I still am not sure that you answered the question about other states' salary pay history laws. And I agree with you that the burden shifting standard in federal case law, it's a McDonnell-Douglas standard, is common. What isn't common, from my understanding of both the Minnesota Human Rights Act and federal human rights laws, and I'm not sure other states' discrimination laws, is that we have a statute that calls out something, some particular thing as being a rebuttable presumption of discrimination. And I'm really concerned that what we're doing is putting something different into that burden shifting standard than what exists already in all of the other situations, and creates a problem in which employers who aren't discriminating have a much harder time of establishing that they weren't doing something discriminatory. And the way this plays out in actual litigation is that that makes it much harder for someone who has a meritorious reason why they did something to get summary judgment. And that results in them essentially having to settle cases that might not be meritorious and might otherwise be shaken out at the summary judgment stage. And so I am really concerned that we're doing something anomalous and different in the statutory language that is going to create some really serious problems for good employers, employers who aren't trying to discriminate. And that's the question that I'm getting at. And I would like some comfort that there is some other statute somewhere that uses this kind of rebuttable presumption language without creating those kind of negative consequences.
Commissioner.
Thank you, Chair. So I appreciate the concern with putting something different in. So the Minnesota Human Rights Act also follows the burden shifting McDonnell-Douglas test. It's not just at the federal level. So this is putting in place exactly what is right now the law that requires that when an employer does something, that they have a burden to articulate a legitimate, non-discriminatory reason for why they did that. They have the burden to do that, whether that is discrimination based on age, discrimination based on race, sex, or here, whether regarding pay history question itself. So that is what is the law at the moment. Nothing different.
Follow-up, Representative Niska.
And thank you, Madam Chair. Just a follow-up comment, which is that we're using different language here than we use anywhere else. And so I'm very concerned that district judges and Court of Appeals judges and the Minnesota Supreme Court judges, when they read the language of the statute, are not going to just interpret this as being the same standard that they apply when we use different language, not defining something as a rebuttable presumption of discrimination. So I hope that we can find some way to write this in a way that's consistent with the rest of the Human Rights Act that also applies the burden shifting standard, and not create a situation where good employers are going to get caught up in a litigation trap.
All right. Representative Scott.
Thank you, Madam Chair. Representative Lucero, thank you for being here again.
Still not.
Oh,
Not senator.
I know, old habits, sorry.
It's totally okay.
Yeah, and I just had gotten a text from
Representative, we all miss him. Representative Scott.
Thank you, Madam Chair. Commissioner Lucero, I guess it's a contagion here. It is really. I'm just having a hard time, based on the back and forth that you two just had, Representative Niska and Commissioner Lucero, I'm having a hard time squaring away why we need the rebuttable presumption language when you're saying already that this is how it goes in your department. And in these human rights cases, there's the burden shifting back and forth. And I can't understand, it seems duplicative to me, that you're putting this rebuttable presumption in on top of what you just said is the way you sort of operate anyway.
Commissioner.
Chair Becker-Finn, Representative Scott, thank you very much for the question. Okay, and so first off, the Minnesota Human Rights Act is over 50 years old, and it is heavily based on both the act itself and substantial case law. So when we're putting in something like this, that's really getting at the systems that are in place. It's different than, it's a slight difference than how you think about discrimination law. This is getting at systemic issues. And so here we just want to be very clear about what the responsibility is. This is also about, I want to make sure that there isn't any uncertainty, especially for maybe employers that don't have an HR team, to be able to say, what is the burden here? And the burden is on you to be able to demonstrate a non-discriminatory reason for why you would have asked for that. That makes it very easy for courts, in fact, to align it with the other burden shifting process, because we don't have this in Minnesota right now. So it will be kind of a first impression to a certain extent when it comes up. So this makes it clear.
Representative Scott.
Thank you, Madam Chair. Commissioner Lucero, does case law back up, I guess, because some states use case law, right, in this, and rather than put it in the human rights portion of their statutes, they go by case law to determine these cases. That's my understanding anyway of what other states have done.
Commissioner.
Chair Becker-Finn, Representative Scott, my understanding is that there are over 20 states that have specifically put something within their laws. And then the laws, the human rights laws or civil rights laws, rely on a lot of case law in interpreting and understanding them. So I think if that helps clarify.
Representative
Thanks,
Scott.
Madam Chair. And so I guess I'll just end by saying we all want pay equity, right? It shouldn't matter, man, woman, whatever. Everybody wants pay equity, and I think that's what we're really trying to accomplish with this bill. And I just think putting that presumption in there is the obstacle here for many folks, especially small employers who don't have their own HR department, who are trying to act in good faith. And I know Representative Niska asked you several times what other states are doing, and I do believe that we would be the only state that would have this rebuttable presumption. And so I think that's what gives us pause on this. I think that it would be 100%, it would be a unanimous vote if we didn't have that presumption there. And it's just, I'm still not understanding that it's really necessary for what's already the way that the Department of Human Rights operates on these sorts of cases. So thank you, Madam Chair.
Thank you. And I can say, as the HR department for my small business, it's, I think, making it really clear, just don't ask. Don't ask and don't use this as you determine wages for folks. So, I actually appreciate the very first sentence on line 1.10 is very clear of what we're supposed to do. And I think that's, Representative Herr, obviously, I'll go to you to close out, but I think that's the idea, is that we're making it really clear in statute so that we're not relying on courts to then make decisions so that then we can apply things further down the line. We're being very clear in what we're trying to do in the statute. But Representative Herr, if you want to close us out.
Thank you, Chair Becker-Finn and members for hearing House File 1625. I really do appreciate the opportunity to bring this bill in front of the committee again, and I just wanted to address a couple of points really quick. Representative Johnson talked about public employers and that being actually public data. The truth is that we do see that in the public sector there's less of a pay gap issue because those salary ranges are actually put out there and they base it on your education, your experience. And so when you look at the data of public employees, they actually have very little pay gap, if any at all, depending on whatever industry they're in. So the concern around public entities, I think, is for us, we don't actually have to worry about that, right? And the other issue around this rebuttable presumption is that if it is, I guess I'm confused as to if this were out, there'd be 100% vote on this, but if this is in, what does it hurt? If we set standards, every state has different laws that are slightly different, and that if we don't take the opportunity at times to be more clear or to be more succinct at what we're trying to do in the message we're sending, then we really have missed the opportunity to say what if states are the same thing as we're doing with the marijuana laws, that where we saw our cannabis bill is that where we see where it's been, it hasn't worked, we change the language. They're not all the same across the state. And so when we have the opportunity to make a law better, we should. And this is the opportunity to do that. And so, yes, other states may not have this, and we will, and that'll make us a better state for doing so. So I just ask this committee support for this bill, and so that we can move it forward and get this finally passed so that Minnesota can start being more equitable in its pay. Thank you, Chair Becker-Finn and the committee.
All right, thank you. Seeing no further discussion, I will renew my motion to re-refer House File 1625 as amended to the Labor and Industry, Finance and Policy Committee. All those in favor, please say aye. Aye. Opposed? No. The motion prevails. Thank you, Representative Herr. And members, we do have a little bit of time, so we're going to skip ahead in our agenda to my bill, House File 133. I will pass the gavel.
Madam Chair, as you're making your way, I'll put the bill in front of us. Would you like to move to recommend that House File 133 be placed on the general register?
That would be my motion, Mr. Chair.
Madam Chair, your bill is before the committee.
All right, thank you. So again, members, yet another bill that we've discussed for a couple years here. House File 133 is simply adding in Chapter 13, so back on some data stuff, allowing for the release of information to tribal nations about their tribally enrolled or descended students. So I think for most of you on this committee, it would not apply to your kids, but it would apply to my kids. And the idea being that folks may not know this, but a lot of tribal nations, we put our young people first, and a lot of funding and efforts go into making sure that our students are supported. However, for various reasons, our tribally descended students are all over the state. So even though my home community is in the Leech Lake area, my kids go to Roseville Public Schools, and this would allow the school to release some data to my tribe so that my tribe could better support my kids. Whether that's, like backpack programs are really popular in the fall with providing school supplies and things like that to Native families. But it might also look like connecting other Leech Lake descended kids who go to Roseville schools, but maybe go to different schools so that these kids can get some extra support from their tribal communities. It's often really challenging if you are a Native kid and you live in a community that's majority not Native, which, let's face it, that's most Native kids in our state. Having that extra help when you're kind of, my kids are routinely the only Native kid in a room. And so to have that extra support from our home community and our home nation could be really important. And so this was actually brought to me a couple years ago by the Department of Education, so it's an effort of theirs as well. So I do have a testifier from Department of Education to speak to the bill as well.
Mr. Tony, please take a seat, introduce yourself for the record, and proceed.
Mr. Chair, committee members, my name is Ado Shuni. I'm the Director of Government Relations for the Minnesota Department of Education. And thank you for the opportunity to provide some supportive and explanatory testimony on this bill. And I want to thank Chair Becker-Finn for persistently championing this effort over the past several years. So I'll just repeat a little bit. Just broadly, this bill would allow districts and charters to share private educational data with tribal nations about their tribally enrolled or descendant students, specifically to support the educational attainment and outcomes of those students. It adds tribal nations as a specific entity to a list of 17 already permissible uses and entities allowed to receive this private educational data, again, for legitimate educational purposes. Currently, we have 37 districts or charters that are required to engage in tribal consultation under the federal Every Student Succeeds Act. And many of our districts and charters are doing and have done a great job in partnering with our tribal nations or tribal representative entities like the Tribal Nations Education Committee to share data, to be able to look at what is the best educational programming for their tribally enrolled or descendant students, or to provide the assistance that these students and families may need in real time. However, there are some districts, based on legal advice, that are determining that since tribal nations are not explicitly listed in the list under Chapter 13 that Chair Becker-Finn mentioned, and decide that they don't qualify as maybe a volunteer organization under Paragraph J, that the district is not allowed to share the educational data with the tribal nation for this, again, legitimate educational purpose without some type of prior consent. And we believe that, while we believe that tribal nations would qualify as a volunteer organization under this list, we do want to address maybe this concern or cautious legal approach, and so we've come forward with this proposal for several years that would facilitate explicit permission in statute for district and charters to have that legal cover that they could share the data with tribal nations, which would allow them not only to meaningfully engage in tribal consultation at a deeper level, but also to provide that real-time data to tribal nations to create that collaboration, that partnership, for the better outcomes of their students and families. Again, this would be for the purpose of enhancing educational programming and real-time support for students and their families, and looking at how that impacts students and how they are doing, and be able to provide advice to the districts or charter based on the data. As I mentioned a little bit, kind of the real-time support for children and family, this would allow tribal nations more opportunities to access the local data that MDE may not receive on a regular or short-term basis, like attendance data, in order to provide quick support services to their tribally enrolled or descendant students. For example, a district could share attendance data with a tribal nation to allow them to support a student and a family with whatever they may need to return to regular attendance if the student wasn't attending for maybe a couple days. This is something that MDE would not be able to provide to the tribal nation in a timely fashion to get that assistance to that student and that family. So this proposal, again, would facilitate a deeper partnership between districts, charters, and tribal nations to support their students and families. And again, Mr. Chair, thank you for the opportunity to provide this support on this important initiative. And again, to Chair Becker-Finn for consistently championing this effort.
Thank you, Ms. Soni. Are there any members of the public that would like to testify before we move on to member discussion? Seeing none, any member discussion? Seeing none, Chair Becker-Finn, any closing comments?
Yeah, thank you, members, for your attention to this. As folks who've been around and been on the Data Practices Commission, this isn't the first time that we've discussed this issue, and just appreciate members' support so we can better support our Native students in Minnesota.
Seeing no further discussion, Chair Becker-Finn renews the motion to recommend that House File 133 be placed on the general register. All those in favor say aye.
Aye.
All those opposed say no. Motion prevails.
All right, members, as folks know, we do have a couple more bills on the agenda. We will come back at 6 o'clock to address those bills. So we will not adjourn. We will go into recess, and you've got like 5 extra minutes to pick up a cup of coffee on your way over to floor. So with that, we stand in recess.